In this video, I would like to talk about some important preliminary matters before we go into special civil actions proper. So important are the following. Number one, the difference between an action and a proceeding. Number two, the difference between an ordinary civil action and a special proceeding. And number three, what special civil actions are. Okay. Kadalasan na pagbabaliktad ng mga lawyers and even law students, no, ang ibig sabihin ng action at saka proceeding. Now, we have to be very technical about this, especially because you are law students and you'll be taking the bar. You have to be very careful about using the terminologies because the terminologies dictate your understanding of the concepts. So may pagkakaiba ang action versus proceeding. So when we say an ordinary civil action, there is a difference between that and a special proceeding. Okay? Consequential ang mga salita. There is a reason why those words are used. And so this will help us remember the concepts better. When we say action, we think of something that's going on, di ba? Yung action. Something that's happening, like lights, camera, action. And pag sinabi natin ang salitang action when it comes to cases in court, we are really referring to causes of action. Yung mga court cases na may pinag-aawayan. Yung pinag-aawayan na yon, yung tinatawag natin na cause of action or the reason for bringing the case. Now, tingnan natin yung definition ng civil action sa Rules of Court. That's in Rule 1, Section 3A. Sabi dito, a civil action is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. See, ang pinag-uusapan sa ordinary civil action or sa civil action in general is right and wrong. Okay? Samantalang ang proceeding, pag sinabi nating special proceeding, wala tayong pinag-uusapan na right and wrong. Kasi special proceeding is also defined by Section 1 and it is a proceeding in which a party seeks to establish a status, a right, or a particular fact. Okay? So, magbibigay tayo ng mga examples later. Pero balik muna tayo dun sa concept ng action. Like I said, when we say ordinary civil action, we are really referring to a case where there is a cause of action. And you have to know the elements of a cause of action. Why? Because this is what will dictate whether the plaintiff will be winning the case or not, or whether the defendant will be winning the case or not. So, pag pinag-aralan nyo yung jurisprudence, ang elements of a cause of action ay the right of the plaintiff, the obligation of the defendant, and an injury or damage that is committed by the defendant against the plaintiff. Okay? So, there are three elements. Pero mas madaling tandaan yung elements of a cause of action by the memory aid ROVID, ROVID. Now, this memory aid was taught to us by my professor in law school, Professor Alfredo Tadyar. And the equivalents of these abbreviations are as follows. R is right, O is obligation, V refers to violation, I for injury, and D for damage. So again, ROVID, right, obligation, violation, injury, or damage. Okay. Ang complete elements would be ROVID, meaning the right of the plaintiff, O, obligation of the defendant, V, violation by the defendant of the right of the plaintiff, resulting in injury or damage. Okay, so yun yung limang elements ng cause of action. And when you analyze a situation, you have to make sure that all these elements are present so that the case will prosper in case you are the plaintiff, or so that you can defeat the case if the elements are not complete if you are the defendant. Okay, yun yung reason bakit nyo kailangan alam yung definition and elements of a cause of action. Now, when you're talking of special proceedings, you're not referring to any cause of action. Why? Because a special proceeding has no cause of action. What there is that the petitioner would like to seek the establishment of a status, a right, or a particular fact. So an example that I usually give here would be guardianship. A guardianship proceeding is a special proceeding where there are two matters that are sought to be established. Number one, that there is a person, the prospective ward, who should be placed under guardianship because that person falls within the definition of incompetent under the guardianship law. The second fact to be established is that there is this person who is qualified to serve as a guardian. Okay, so pag tinignan niyo yung proceeding for guardianship, walang nag-aaway. There is no cause of action. What there is the desire of the petitioner to establish a particular fact or a status. So, yun yung importansya ng pagkakaiba ng salitang action at saka proceeding. Like I said, you have to be very technical so that you will understand the concept very well. Okay. Now, when we say, again, obligation. Okay, di ba yung one of the elements of a cause of action is the defendant's obligation. Dapat i-connect ninyo to sa prior knowledge. Ano ba yung mga sources of obligation? And where do you study this? This is in the law on contracts. So you have 5 sources of obligation. Law, contracts, quasi-contracts, delicts, and quasi-delicts. Okay? And this is how you identify whether there is an obligation on the part of the defendant. You make sure that the obligation comes within any of these 5 sources of obligation. All right, so this is how you fully understand the concept of special civil actions and special proceedings. Now, that is also important for you to remember that because of that difference between these two types of proceedings or actions, the parties are also different. So do not confuse them. A plaintiff is the person who has a claim in an ordinary civil action. Okay? Hindi complainant, plaintiff. That's what the law provides. And a defendant is a person against whom the claim is made in an ordinary civil action, hindi respondent. Okay? So, ang sa special proceeding naman, like I said, hindi sila nag-aaway pero may hinihingi yung nag-file ng case. So, because that person is asking for something, he is petitioning the court for something. That is why he is called a petitioner and not a plaintiff. And the other party, if there is another party, is called a respondent and not the defendant. Okay? So, yan yung sa special proceeding. Ngayon, sa special civil actions naman, meron din yung cause of action as a general rule. Kaya ang salitang ginagamit ay action. Pero may mga exceptions. Kaya special. Okay? There are some provisions that apply only to particular special civil actions. And in situations where the rule for the special civil action does not provide for anything, that's when you apply the general rules of procedure in the rules of court. Okay. Now, I would just like to proceed to another important concept. Okay. Ano yung mga certain types of, certain differences between or among these actions or proceedings? Like I said, there is a difference in the designation of the parties. Also, may mga special rules tungkol sa jurisdiction. The general provisions on jurisdiction of courts, meaning jurisdiction over the subject matter, they are found in BP 129 as amended. All right? Kaya lang, So dito, pag walang nakaspecify kung saan ipa-file yung case, you go to BP129, the rules on the jurisdiction. Kaya lang may mga rules ang special civil actions indicating that certain cases can only be filed in certain courts and meaning jurisdiction or also in certain venues. For example, a forcible entry and unlawful detainer case. That is to be filed only with the first level courts, the municipal or the metropolitan trial courts, regardless of the amount involved. That is an exception because the general rule when real property is involved is that the jurisdiction of the court will be a maximum of 50,000 pesos if within Metro Manila and a maximum of 20,000 pesos if outside Metro Manila, but that is based on the assessed value of the real property. If the action refers to title, right, interest over real property, including foreclosure of mortgage and partition. Kapag hindi naman real property, pero capable of pecuniary estimation, the jurisdictional amount is maximum of 300,000 pesos, that is outside Metro Manila, or maximum of 400,000 pesos within Metro Manila, if the jurisdictional amount is 300,000 or 400,000 pesos. Sa ano yun? Metropolitan or Municipal Trial Court. Okay. Kaya lang, like I said, if it's a forcible entry and unlawful detainer case, kahit ang claim for damages is 5 million, sa Metropolitan or Municipal Trial Court pa rin. Bakit? Kasi yun nga yung special rule for this particular special civil action. Of special civil actions, there are 10 that are found in the rules of court. I'd like to enumerate them. Okay, you have interpleader, you have declaratory relief and similar remedies. Ngayon, itong declaratory relief and similar remedies, these are separate. Okay, iba yung declaratory relief, iba yung similar remedies, but they are fall under one rule, and that is Rule 63. Next is we have review of judgments and final orders or resolutions of the COMELEC and the Commission on Audit, that is under Rule 64. Next, we have certiorari, prohibition, and mandamus under Rule 65. Ito naman, these are three separate special civil actions under one rule. Okay? CPM, certiorari, prohibition, and mandamus. But you must differentiate this from a petition for review on certiorari, which is an appellate proceeding. This petition, Rule 65, is a special civil action that is original and not appellate. Okay. And then we have quo warranto under Rule 66, expropriation under Rule 67, foreclosure of real estate mortgage under Rule 68, partition under Rule 69, forcible entry and unlawful detainer under Rule 70, and contempt under Rule 71. Gusto ko rin i-point out na ang Rule 64 at saka Rule 65 parehong certiorari. Kaya lang these two rules refer to different matters. Okay, Rule 64 is certiorari as an appellate procedure for decisions of the COMELEC and the Commission on Audit. Rule 65 is certiorari as a special civil action that is not appellate in nature. All right, so we will be discussing more of this in subsequent lecture videos.